Can you build an ADU in your backyard in Utah? The answer depends on what kind of accessory dwelling unit you're creating, and that's the key term to understand: accessory dwelling unit, or ADU. An ADU is an additional living space on your property that's intended to be rented out for 30 days or more. Think mother-in-law apartments, garage conversions, and sometimes even tiny homes. ADUs come in three main categories: internal, attached, and detached. Internal ADUs are within your existing home's footprint: a basement apartment, a converted garage that's attached to your house, or a loft space. Attached ADUs consist of a new or expanded structure that shares at least one wall with the main house but has its own separate entrance. Detached ADUs are separate structures: a standalone tiny home, a converted detached garage, or a purpose-built cottage in your backyard. But what makes something an ADU? If you expand your house and add another bedroom, that's probably not an internal ADU. But if it creates a separate living unit with its own entrance, kitchen facilities, and a private bathroom, and you intend to rent it out for 30 days or more at a time, then you've created an ADU. Conversely, if you add a bathroom to your existing detached garage, probably not a detached ADU. But if that new bathroom means your detached garage now has a kitchen and bedroom space, then you've probably created a detached ADU. Traditionally, whether you could build an ADU is entirely up to your local city or county, and until recently, that was especially true for detached ADUs like backyard cottages. But that's starting to change, and we'll cover the new rules in a moment. But in the instance of an internal ADUs, state statutes trump local laws, because the state legislature passed a bill in 2023 which made internal ADUs a permitted use in a single-family residential zoning district. Here's the main rule for internal ADUs. Utah property owners have a right to build one internal accessory dwelling unit. It must be within their existing home's footprint. Only in very certain circumstances may a city or county prohibit an internal ADU. For example, a city or county can prohibit the creation of an internal ADU within a mobile home, or prohibit the creation of an internal ADU if the home is being served by a failing septic tank. Architectural standards for the ADU must be consistent with those for single-family homes in the area, which shouldn't be a problem if it's internal. Cities and counties can also prohibit the creation of internal ADUs with a zoning district covering an area that's equivalent to 25% or less of the total area in the municipality or unincorporated area of the county that is zoned primarily for residential use. They can also prohibit the creation of an internal ADU if the lot containing the home is 6,000 square foot or less. Other regulations also exist, so be sure to check Title 10, 21, 303 of Utah Code for compliance, as well as your local ordinances, of course. Cities and counties can still regulate utility connections and other infrastructure requirements, such as parking, as state statute requires one additional on-site parking space for an internal ADU unless you already have 4 or more parking spaces on your property. Statute also says they can require replacement of any parking spaces contained within a garage or a carport which is converted into habitable space. Now, what about that tiny home in the backyard? Here's where things have really changed. Starting in October 2026, state law requires that most cities must permit detached ADUs by right on any lot of 11,000 square feet or larger that already has a single-family home on it. You won't need a conditional use permit if the property is in a primarily residential zone. That said, local governments still have real authority over the detail. They can still regulate setbacks, height, parking, design, and utility connections. They can still prohibit detached ADUs on smaller lots, in front yards, or where utilities won't have the capacity to support. What they can no longer do for qualifying lots in those specified cities is simply say no altogether. If you're in a smaller city or in a county's unincorporated area, detached ADUs remain entirely a local decision. Check your local code. Of course, the building code will also apply. So to sum up, if you're looking to finish your basement or convert part of your house into a mother-in-law apartment to rent out, state law in Utah has made that easier in most residential areas. Just make sure you verify your local ordinances, because internal ADUs may still be regulated or even prohibited in certain designated areas. And if you're planning a detached structure like a backyard cottage or a standalone tiny home, that depends entirely on what your local code allows. This educational content was developed for the Land Use Academy of Utah. Funding was provided through the Land Use Training Fund, which is administered by the Office of Property Rights Ombudsman, utilizing a portion of the 1% surcharge on all building permits in the state of Utah. The role of this organization in administering funding is primarily administrative and should not be viewed as legal advice. Always consult your legal representative when addressing land use activity.